you guys, it's Mo from Mo in the Deep End, and I'm here with Cara Wieneke, and we are going to talk about the Delphi case, maybe get some insight from a real appellate attorney about, well, what the hell is going on with this case? Because at this point, the matrix is broken for me with this case. The simulation has gone out of control. We need to unplug it, wait 10 seconds, and put it back in. So I guess my first question is, when will we get a transcript? Why are all of the exhibits being withheld from the public?
Good question. Nothing about this case is normal. So
Okay.
the exhibits not being provided, not normal. The media being allowed to walk into the well and see some of the exhibits, but no one else, not normal. We have half the transcript or half the case has been transcribed, and various people have some of them. But if I understand right, none of them have exhibits because we've been denied exhibits too. And so when are we going to get to see like a full transcript of all the exhibits? When it's filed in the appeal, then lawyers in particular will be able to just click on them and pull them down. But that could be 6 months.
Okay. Well,
Longer.
because I was under the impression that the appeal couldn't really start until you had all the transcripts, because isn't that what you guys go through as sort of looking for things and errors?
Yeah, so the appeal can't even start till this motion to correct error is decided, or until it's deemed denied, which I think is after 45 days of filing. If like the court
Okay.
takes no action, they'll treat it as if she's denied it, and then
All
the
right.
appeal can start. Once the appeal starts, they immediately ask for the transcript, but it will depend on how long the court reporter takes to transcribe it. My guess is she's not going to take much more than, I don't know, maybe she gets 45 days. She might take
Okay.
60, 90, but
Yeah.
she's pretty quick. And so I expect she'll probably have it close to time. But then the appellant, the appellate counsel, they get to take as long as they need, within that 30 days. They'll get initially 30 days. They'll probably ask for more, but they get to review everything. And then when they file their brief, that will then trigger the court reporter. She has to file
Okay.
the
All right.
transcript, and that's when everybody will have access to it. Um, it could happen sooner if, like I was kind of throwing out there, you can always file a request for public access. You can file something saying,
Yeah.
why is all this closed down? But there's this whole thing of, is it going to take longer to just wait it out or to actually get access? And the other thing is, if you ask for the transcript, they'll prepare one for you, but you have to pay for it. And it's going
Yeah.
to be,
I was hearing it was like 575 per page.
yes.
And is that a normal price kind of fee, or
It is for people who order it privately. Now,
okay.
when Rick orders it through his attorneys, he won't pay anything for it.
Okay, that was the one concern, because we do have another case where we're working on an appeal, and the first hurdle was having to pay for the transcript for
Right.
his attorney.
And I tell my private clients, hey, sometimes that 575 or whatever is pretty high. So sometimes the court reporter fee might be almost as much as the attorney at times. That's not unheard of. I would imagine this transcript, I would think $20,000-$30,000 wouldn't be
That
unheard of. Yeah.
that's kind of what I was ballparking, because it with the cost per page and then how long the trial was, because it includes the hearings, correct? So
Right. Yep.
I
If
mean, this
you
has
ask for
been,
them, yeah, you can pick and choose what you ask for. If I were the attorneys, I would ask for everything because
yeah, I don't.
it's a mess.
So with this appellate case and kind of the corrections going through, now with this bombshell of Ron Logan, does that trigger anything as far as the case, with the fact that the prosecutors did not turn their knowledge of it over? Could that be a Brady violation?
Well, we haven't heard from the state yet as to what his position is going to be.
He's
Although,
playing an invisible piano, and I am embarrassed to say that I do an invisible guitar when I'm thinking.
oh yeah,
So it really irritates me. Like,
that was a
hold on.
great video, though.
Oh,
People talk with their hands, right? And I imagine, as a trial attorney, he's probably more likely to. but I'll be interested to see how he responds, because he's kind of in a corner, right? He
Yeah.
either knows about this video and that's going to look bad, or he doesn't know about the video and that's going to look bad.
Yeah.
Um, it's going to be really hard for him to say the video's not authentic because it came in discovery. So, if it's not if there's something inaccurate about the video, technically he's the one that turned it over. So that's going to be that's it, he's in a I don't know how he's going to respond, honestly.
Yeah, he is in a catch-22 because if he says he didn't know about it, then it shows that he didn't take care with all of the various, discovery. If
Right.
he says he did know about it, then it's a Brady violation. I mean, regardless if the time is maybe wrong, because a lot of those security clocks, they can run on wrong times, labeled as wrong times. Regardless, this is something they didn't investigate, didn't
Right.
interrogate, didn't, place on their timeline, their magic timeline, this doesn't work. So it really is interesting to see what of the plethora of appellate issues will be picked by
This is
the attorneys.
that's going to be the appellate attorney's problem, is how are they going to pick and choose which
Yeah,
issues, because you only get so many pages or so many words. You can ask for more, but they're not going to give you a lot more. So it's really going to be them trying to decide how to narrow things down. If anything, though, at least the court will look at everything in the record. And so this information, what I thought was interesting, I've seen people complain they aren't sure about the timestamp, and we know the timestamp is off by 12 hours because it
yeah,
says it's at midnight, but it's clearly not midnight, right? Or I think it was just 2 a.m., 2 4, whatever time
yeah,
it was, 2:44 a.m. Clearly not 2:44 a.m. So that's
no,
an easy one. But I did see that they included, even if it's, some people say, oh, maybe it's off by minutes. Well, except that then there's that FBI phone pinging thing that said his
yes,
phone pinged at his house at about 2:50. Well, that kind of matches up with the time on the camera. So,
yeah,
again, though, it's the question is, if Nick did know about it, then it seems like it's a pretty, he's expected to, the knowledge of it is imputed to him if he knows that the tape existed, or even if law enforcement knew the tape existed, which they clearly did. They impute that knowledge to him as the prosecutor, because he has a duty not to put on false
yeah,
testimony. Now, a lot of people thought, oh, well, Brad Weber lied. Not necessarily. I didn't see anything in the motion that said that Brad knew about this video, that he'd been shown this video. They're asking a guy, what time did you get home 8 years ago? I
yeah,
mean, yeah,
that
he may have just been, kind of spitballing a time when he thought he arrived home. So I don't fault him at
yeah.
all for that.
No, it is amazing that you have all these surprise witnesses that came up, weren't really mentioned, or now they have a very clear memory of something that they were somewhat spotty about during their initial timeline or initial interviews. If you were the attorney in this case, what would be your main sort of attack venues, or what are the most egregious things that you would highlight first?
I actually got to talk to one of his appellate attorneys, and
Oh,
there
cool.
was a good idea that the kind of the way I looked at this case, there's so much wrong with it, in my opinion, that the hard part's going to be kind of getting it down to the bare bones. And I thought, you look at it sort of like the entire proceeding is unfair. That's sort of your umbrella argument. And then you could put all of the different errors in different buckets. So you might have, a Sixth Amendment interference with counsel bucket, and then a right to present a defense bucket. You could put more errors in. Judicial bias could be a bucket, and you put all of these, you sort of group them based on these
Okay.
different errors. And then at the end, you want to bring it together, I think, and say, from start to finish, this thing was just mishandled, quite frankly. And there could be a lot of different, reasons why. That's what I would do if it were me.
Well, what about the kind of explosive, you know, revelation that Richard Allen was represented by an attorney, but the attorney was not present or even allowed to represent his client's interest during the safekeeping sort of secret meeting?
Yeah, if everything that's put in the motion to correct error is true, and that's based on statements from this attorney, saying I talked to the prosecutor, I talked to the sheriff, so it looks like everybody knew that he was representing Rick. That's going to be a very tough thing to get around. I don't know how Rick's going to or how Nick's going to respond to that claim, because the idea is that was a critical stage of the proceedings, his safekeeping proceeding. Can't even call it a hearing because one wasn't held. And so you had a right to an attorney. And in Indiana, we attach that right to counsel at least as early as an arrest. If not
Okay.
earlier, there's some question if it's earlier, but at least as to the arrest. So he has an attorney. Apparently, the state knew he had an attorney, and they held this critical stage without letting his attorney know and giving his attorney the right to be there. And people are like, well, yeah, but what's the harm? We don't have to figure out what the harm is.
No.
If he can prove that violation, we presume because it was a critical stage, there's harm. And so the only way to fix that is you get a do-over. You get to start back over again. And
So
that's what the remedy is.
so that would be a new trial. Would that necessitate a replacement of this current judge, or would she continue to be the czar of this case?
She would continue to be the judge on this case because she wasn't even involved at that point. And so
Okay. Yeah, it was Diner.
right, so that wouldn't even be like, that's no fault of her own, what happened here. But no, it would go back to basically the filing of the charges, back that far.
Okay.
Yep.
What it was a little weird to me that Diner's daughter was a prosecutor in this case after all of the
Well,
sort
people
of
said they weren't related.
oh, okay, never mind. I was thinking they were related.
Yeah.
But then again, I've
I
also
know that was a
slept
lot of
since I've
question
read
if they
things.
were. What's that?
I said I've slept since, I read things, so
That there were a lot of questions about that, and so I don't know. I did hear, and I haven't checked, but I think this is right, that before working at the prosecutor's office, I think that Stacy worked at oh gosh, was it Andrew Akey's firm? Somebody's firm that
uh,
for a moment represented Keegan Klein. So that's the only connection I have seen between her and this case before that. But I've heard that they're not related. She and the judge aren't.
are there any rumblings behind the scene? And if you can't say anything, that is fine. Will the FBI finally come off of all of the information that they were gathering? I mean, they lost an well, not a semi-agent, but I can't imagine that someone Molotov cocktails, a Terre Haute FBI agency, and we don't hear anything about it.
That's a good question. I know the defense before trial was trying to get the FBI file. I don't know if they ever got it. I haven't heard if they got it. We didn't really see evidence of it. And of course, again, another very unusual thing in this case, the witness and exhibit lists were all like you couldn't see them. They were filed confidentially. Never had that happen before. Normally, what happens is they will at least have the names of all the witnesses and sort of a general exhibit like autopsy photos or whatever. So it's kind of we don't know who anybody was planning on calling, so we don't know what the defense had. I think we'll find out. If not through the appeal, we'll know through post conviction. If he gets to that point, if he has to get to that point, or on retrial, hopefully by then. I kind of was following the guy who has been accused of killing Ferenczi. I was following his case in the federal court, but I think he was declared incompetent, or
Yeah,
the
I think
evaluations
yeah,
may have come back. So we may never know, from at least not from him.
yeah, it does the state did itself no favors with this complete lockout of information.
Right.
And, it's hard to complain about conspiracy theories coming up when you won't give us any information. the general public understands that you can't give us everything, but some information would be great. Had they been able to had we been able to stream and we could have seen the timeline, we could have asked.
Right. Right.
It's just none of this seems normal. And
It's not at all.
a and that's the problem. People have seen this, and this is a great stain on Indiana. I have had to explain Indiana so many times. I'm like, "I don't know."
Yeah,
What
literally everything that about this case is unusual. It maybe even unique in that it's never happened before. I've just
Yeah,
never seen. Somebody said too when, and I don't know if this was in the motion to correct error, it may have been, that when they arrested Rick on the 26th, which we didn't even know until trial, it was the 26th, he was placed in the jail under an alias. Never heard of that before in my life. Not from arrest, and to the point that I thought that somewhere in the motion to correct error, they mentioned that the attorney had tried to call to meet with Rick, and they didn't even know he was in the jail because they didn't have him down in as his name, his real name. So again, this is all never heard of this before. It makes no sense.
now, is it an appellate judge or an appellate counsel that will judge the appeal, or does it go back to Gull? Because I don't see it
So
happening.
yeah. So what happens is it will be decided by a 3-judge panel in Indianapolis. They're from the Court of Appeals. They meet on 3-judge panels. We won't know who the panel is until either an oral argument is set or the decision is rendered. The panel is decided. They have some kind of algorithm that's a random assigning. There are a couple of judges that may not be able to sit on the case. I've heard there might be some conflict, but other than that, it'll just be a random panel. And those 3 will decide. It's an intermediate court. So even whatever they decide may not be the final word, because either side can then ask the Indiana Supreme Court to take it. Court doesn't have to take it, but I wouldn't be surprised if they aren't going to pay more attention to this case just because of its notoriety.
Where where is the I know that there was some talk before the trial that the, habeas project, I think that's what it's called, was very interested in this case. Is the interest still there? I mean, does he have any recourse? I guess I know it's a state case, but this is such a travesty. Does he have any independent or outside recourse? Because we've already tried the Supreme Court and they kept Gull on despite numerous errors.
Here's the way I look at it. Yes, there is interest, but now now that he's been found guilty, so it'll be different on appeal. They have they're looking at the trial court errors, but from a post conviction standpoint, now really whoever gets involved in that process, let's say he loses on appeal, they're really going to have to almost solve the crime. They're going to have to figure out who did this, or at least come up with kind of a unified, obvious theory based on. And there seems to be quite a bit of stuff that could be done, investigation wise, that hasn't been done yet. And so the innocence projects that generally I reach out to, they usually want to know, is there DNA evidence? The great thing is we know there is in this case.
Yes. Now, wasn't there an order put in to preserve a lot of evidence? Now, my faith in an order signed by anyone, considering we lost, what is it, 30 days of no, 90 days of recording.
Yeah, something like that. Yeah. Yeah.
You know, and
And that
we
there
didn't
may
have
or may not have been a list of what we
yeah,
lost.
we have no idea who we interviewed. Thank you very much.
The good news is, at least with the DNA, a couple of things. One, we have a state statute that requires it to be preserved.
Oh, good.
And number 2, because we think it went through the crime lab, I don't know how much, like if all the DNA evidence went there or not. The crime lab has their own retention policy, and they're very good about retaining this evidence. So I think there's going to be evidence to test. Now, the question is, you have like wasn't there like a scarf or something found at the
I
scene that nobody ever knew who it went to?
There was a belt. So the things that we learned about that were kind of new were a belt and a cigarette butt, I believe.
Oh, right,
Maybe
right.
maybe there was one other thing, but again, I've slept since then.
Yeah, they said
But
that there was a scarf that didn't belong to anybody. Nobody, none of the, like, it wasn't the girls. It didn't seem to be anybody's. And I don't know if they retained that. I hope they did. But those could be tested for DNA. Now, those, if they destroyed those, you know, that would be a problem for post conviction. Obviously, this case is unique in that usually we tell clients, hey, wait till your direct appeal is done. But in this case, we really haven't. We've, there's a group of us that have tried to approach some different innocence projects about getting involved because we are concerned, hey, if he wins on appeal, great. You can use this information on retrial. If he doesn't
yeah,
win on appeal, you can cut the amount of time because, we are concerned. They've put him right back in the same exact spot he was in
ye
pre-trial. Uh,
yeah, I
People said he was displaying some concerning behaviors during trial, at least if you believe that juror's interview that he was, I think it was the juror that said he was eating Post-it notes or something. Um,
yeah, I mean, the thing is I am very much leaning toward a professional jury pool. I would like that. I They do it in Denmark. I
right,
didn't, you know, but we have so many jurors that do not understand basic law, and you get like what a I did jury duty. You get a 10-minute sort of refresher course on, what is probable cause, what is reasonable doubt. But if I hadn't been there, I mean, there's a lot of things they didn't understand that because I'm a nerd watching trials, I can tell them.
right.
And Indiana is so unique because I thought they were lying when I went to jury duty because they're like, "You can talk about the case, just not deliberate." And I was like,
Right. Which, according to the juror who was interviewed, it didn't sound like they did that too often. Because I think she said something like, there wasn't much to talk about or whatever until the end, which is, although they were, apparently having conversations about all sorts of other stuff like the defense attorneys and prosecutors kind of chuckling and things. But at the same time, I see your point, but I also sometimes I think trial attorneys. I get the privilege of Monday morning quarterbacking, but sometimes I think trial attorneys forget that ultimately jurors want to know what they want to solve the crime themselves. They want to know what happened, and if the state
"Yeah,
comes with a story, which Nick did, he had a good story. If you come with a story, they want to hear, they want to pick which story is probably true. And I think the hard part here, you could hear it in her interview. The jury seemed to ignore the facts that didn't match the story. And I have to assume it's because they weren't given another story. The defense wasn't allowed to tell their side, really.
well, I will say that you have a man here who is accused of being a monster." And then they were shown graphic photos of these little girls. And do you wanna be the one person who gets it wrong, who sets
Right,
free a man that was potentially, did these horrible things? I can see the seductive, kind of pull of that, and the fear. I mean, when I did jury duty, I didn't sleep well the night before because I knew I was going in and I would be choosing someone's life. I mean, even if
right,
it was just a traffic ticket, that is going to affect someone's life. And I can imagine if you sit there and you're watching the victim's parents and their family crying over there, and you have a gentleman who, regardless of whatever mental capacity he was in, he confessed a dozen times. And you have you have a psychiatrist saying, "Nah, he wasn't crazy." You have guards saying, "No, he
right.
wasn't crazy." It would be incredibly difficult to be the lone voice that says, "There is no case here."
Yeah, it would. And I think at one point, I thought she said the vote was 8-4 or 7-5 guilty. So that was a decent split. So it wasn't sort of the lone juror getting ganged up on. It's just to me, just listening to it, I was just really surprised. It reminded me again that, It's all about the story you're able to tell. And if you're the only one telling a story, and the defense isn't telling its story, because I think she even said in her interview something like, if he didn't, like, they didn't put anybody else up as the possible bridge guy, so of course we knew it had to be him.
I haven't seen that interview. Was she told that they could not tell her anything?
She found out after the fact because she listened to this podcast's episodes,
Oh,
and
which podcast? Murder
murder
Sheet?
sheet, murder sheet. So they're pro prosecution. So she heard that thing, but she said, I didn't really think it changed my mind so much. It's just that I don't know how much information she really got of the other story. I mean,
Yeah.
see some things on the internet, that sort of thing. But I have to wonder if she had heard this information about Ron Logan confessing, allegedly, um,
Yeah. I
Elvis
have a lot of
allegedly confessing, all these other false
y
confessions. Maybe she
yeah,
would have seen,
it
yeah.
is odd. I hesitate with the Ron Logan thing.
Yeah,
It physicality, that's been a big point with Richard Allen. He's a shorter man with heart issues. You have Ron Logan who's carrying a doggone, oxygen tank. It doesn't make
right,
sense. And I'm not saying, it's not possible that he
right.
pulled a Kaiser Sose and he was, fit as an ox and just walked around with a fake oxygen tank. But this is a high risk area. If you've been to the Delphi Trail, you can hear from the
Yeah,
freeway. You can hear different conversations, the acoustics, an open space. None of this makes sense for a
no,
first time crime and a man who has fantasized about it. If he had fantasized, it would have been, I would think, a gradual buildup. Like he might start looking in windows. He might start watching kind of grosser adult films. He might start, taking lingerie, maybe have one assault or kind of a, disorderly or lewd acts out there. I mean, this is something that doesn't just come out of nowhere, and in fact, it really reminded me of the, Memphis 3, the
right.
West Memphis 3. Very similar, very close to a freeway, young children involved, you know. Can I say how disappointed I am that we finally have a MFing cult thing? Like, we finally get the Satanic Panic, and
That's
and
never
Indi
true, right? But here it might actually be. Yeah,
and Indiana's like, "Nah, it's just a
yeah.
weirdo." I'm like, "No, no, the 1980s are screaming at you. You finally have one. You
Well,
finally
and
found one."
you add in the weirdness of the police interaction with the public, because we had old bridge guy, no, 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 young bridge guy, no, 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 they're the same guy, which nobody believes that. And then you had the Keegan Klein, Anthony
Yeah,
Shots thing thrown in there. They go out, they went out and interviewed somebody in another state.
yeah,
Um,
I think that was Daniel Nations. If you pull up Daniel
yeah,
Nations, he looks exactly like Bridge Guy,
you know
and
what?
he does.
Everybody looks like bridge guy. I
Everybody
feel
looks
like,
like Bridge
yeah.
Guy except for the guy who lived there for 7 years that no one noticed.
Well, exactly, exactly. He doesn't appear to fit the picture. You've got. I mean, there's just so many possibilities as to who could have done it. I think. I think if the defense had been allowed to present a defense, I'm wondering if they would have gone the route of picking a theory, or if they would have simply put it all out there and said these are all equally as culpable as our client. I don't know what they would have been permitted to do, or what they would have ended up doing with that. What's interesting though is we have this unknown male DNA profile, with partial profile, I guess, big enough to
Yes.
exclude people, large enough to do that because they excluded Rick, but otherwise we don't know who it belongs to.
Have they
And we
done phenotype, DNA? Well, could it because the people of, the county, Carroll County, have been charged for ancestral DNA analysis.
They
So
have, and I
where did
don't know what that was for, on
well,
what
it
piece of
probably
evidence.
wasn't for the hairs they tested, the second day of trial.
But right. And what else I wondered, and I don't know if they did this or not. If you could compare the profile, the unknown male DNA to Rick, did you compare it to Ron, Elvis, to everybody, to family members?
Yeah, well,
Because you can't match, but you can exclude. Did you
well,
exclude all
with
of those people?
with the phenotyping, they should be able to tell where this person originated from. Generally, what ethnicity they might have, maybe
Right.
even eye to hair color with some probability. So you can eliminate a lot of people. This case is crazy.
Yeah.
It's I mean, it's essentially down to a bullet that they tested by not testing it with apples and oranges. It
I mean,
was
interestingly, that juror didn't put any weight on the bullet at all. I thought that was actually, that was a good sign. Like she had listened to that evidence very carefully and was like, yeah, it really wasn't a factor for me.
Now, I do wonder if, in your opinion, for future lawyers, I think they are going to need to start teaching lawyers how to craft stories, almost how to interact. I do think you might need to take some drama lessons. I'm sure Justin Trudeau is going to not be busy. But I think lawyers, and you kind of see it on YouTube, and they're very smart, they're great, but they get into the technical things. So it is nice to have normal people, okay,
Right,
normalish, watching, because I think sometimes lawyers can forget that they are really talking to normal people.
right,
And some of these cases, some of the information is so incredibly dense. Finding an expert that can clearly communicate is better than one with all the credentials.
right. I
Me.
agree, and that's part of the. I know trial attorneys. A lot of them will go to CLEs and seminars to learn how to craft the story. And that's, I think, the hard part with a case like this is it's so big, and there seem to be so many theories. You really had to, they had to really figure out what their story was. And I don't mean that like, it sounds like you're like faking and
No.
lying a story. Hey, the state story is simply that too. None of us were actually there when the crime occurred, so we're all trying to figure out what happened based on the evidence. It's a story, essentially. But that's the thing. The state always has a story. They always tell you what they think happened. And so sometimes the defense had no other choice. They had to come in and try to poke holes in the story because they weren't allowed to tell their own story. In normal cases where third party, guilt is permitted in, that's what they do. You'll see them tell that story. And it would have been fun to see, and hopefully we'll get to see someday what the trial would look like if they had been permitted to tell their story.
Now I know Judge Gull disallowed the third-party evidence because of no nexus. How big does a nexus have to be for it to be for Judge
Here's
Gull?
here's it's I'm trying to think if there's a lower bar than Nexus. Essentially, they don't want, um, defendants, or no, I shouldn't say, they don't want some guy's ex-girlfriend coming in
Okay.
and saying, I think my husband did it. Let's take Ron Logan's perfect example. His ex-girlfriend has done some interviews and said she thinks he's bridge guy. But she also says, I don't really have, I can't say for sure. He acted this way. He was, she gives some reasons, but they're kind of speculative. Let me say it that way.
Yeah.
That probably wouldn't be a nexus, because it's just pure speculation. But we have way more than a
Well,
nexus.
I mean,
Yeah,
we've got the Delphi report, we've got, possible unknown male DNA, we've
right,
got the fact that Richard Allen's DNA was nowhere there. I
right.
just
She actually
how
said there's no DNA, but I think she kind of likened that to that being a nexus. There needs to be some DNA. Well, there was no DNA putting Rick there, so that there's no nexus there. And you can't say the confession's a nexus because we have other confessions, right?
yeah.
Other people confess, so shouldn't those at least have been a nexus for third party guilt? So, that to me is certainly a strong issue. I'm not sure. And there's even some argument that you don't need a nexus at all, really. You just need to be able to put forth some evidence that has some sort of, you know, basis for it other than just pure speculation. And that clearly, you know, based on what I know, that there was more than enough of that. So I do think that that's going to be a strong issue for the appeal.
Do
Can't say
you
it'll
think
win, but
this case is going to spark judicial reform in Indiana? I mean, we have seen what a judge hell bent on being biased and non-responsive, combative to the defense. I mean, at what point does this judge cross a line that it gets taken care of? Because I don't see any line that she can't cross at this point.
well, the line. So, do I think there'll be judicial reform? Probably not, because honestly, I understand a lot of people see there being evidence of bias, but the process, the reform is you've just got to bring that up on appeal. We brought it in the original action, but admittedly, you know, we worried that what we thought happened at trial was going to happen. You know, we even told the court that we were concerned moving forward. This is going to be difficult because she thinks that she said they're not competent to represent him.
Yeah.
So we thought that was going to be a problem. The Supreme Court didn't agree. We were like, okay, but now that just means that now the process is that can be raised on appeal, and they can say, look, this judge was biased, and the remedy, you get a do-over, because again, it's really hard to not show that there's a prejudice there if you've got the judges making, you know, important rulings on the evidence, if there's a bias there.
Well, the lack of parity in funding should be a clear source of bias, I would think, unless that's something that happens in a lot of cases. I
You
don't know.
know, that's a good question. It does happen in cases sometimes. I don't know how, by the time this was all over with, I don't know how, whether they were getting the money that they need or not, because again, everything was filed ex parte on that. And I understand why. It's interesting, and you can't really tell from Carroll County's statements because they grouped a lot of stuff together. But yeah, I mean, we know going in most cases, the state's going to have more resources. They always do because they have a
Well,
free lab,
yeah,
you know. Yeah,
yeah.
free cops. But so I don't know. And I was trying to think about that. Even if they had been permitted to present, well, if they'd been permitted to present a third party guilt defense, yeah, there could be a lot that could have been affected by the lack of an expert. But you know, otherwise, in the case that they were permitted to present, you know, I don't know. I don't know so much. They called experts, but if you're not allowed to present evidence that respectfully that your client didn't do it, somebody else
Yeah,
did, that makes it tough. Yeah.
it it really is very eye-opening, and I hope people are paying attention. And I do think that this will have a chilling effect on people coming forward.
Oh, I
You know,
definitely think it will. Yeah. That's always a concern. You know, when something like this happens, and the circumstances around all of this are just, it's just very weird. Uh,
it's very weird. It's very weird that, Richard Allen probably went into the interrogation more clever than most, more knowledgeable than most because he watched a lot of, Dateline and things like that. And it is very interesting to kind of hear his defiance in the transcripts before they started threatening his wife.
right.
And as a juror for me, that would have stuck out. That would have stuck out amazingly because he kind of had a cocky, kiss my ass sort of attitude. And then they brought in Kathy and he was like, no, no. So
Common tactic too.
it
Um,
is,
yeah.
but it is very, very interesting because he reacted like every single, I mean, not that I'm a bodyologist or anything, but he reacted like everyone on the behavior panel told me was innocent.
Right. I know.
Very indignant that he was even being accused. I mean, most guilty people will be like, "I didn't do it." But innocent people be like, "Get me the hell out of here. I didn't do it. Y'all are stupid."
Right. And it's funny when you read the handbook for how they learn their techniques of interrogation, some of the things they're like just openly contradictory, like looking at the cop too much but not looking at him enough. They can make anything fit to make them think that they're guilty. Once you get to that point, I mean, really, it's you can't say this enough, you should never ever cooperate with and go in and talk to them. It never turns out well. You're not going to be able to clear yourself if they're calling you in for an interview. Chances are they're trying to get information from you.
You is the
And
suspect.
yes,
If they
yes,
read you Miranda rights, use your right to remain silent.
absolutely. Yes. I mean, and you saw that in this case. He goes in, he gives an interview, thinks he's done fine, and then comes
Yeah.
back to pick up his vehicle. And that's when, that at that point, they had already decided he was guilty. You
Well,
should
yes.
Yeah, you should know that they probably decided you're guilty because they searched your vehicle, right? I mean, they
Yeah.
obviously think you're a suspect now. There's really no reason to talk to anybody at that point. But people do. They think I didn't do anything. I'll be able to talk to the police. And you can. And he didn't say anything incriminating
No.
in that video, but didn't
Do
matter.
you think that this is going to open a larger question about the Reid technique? Now, police in Europe use, I think, the peace technique, which is less confrontational.
Right.
The Reid technique is definitely hard to beat. I mean, you're basically you're invalidated every time you tell the truth. So if you didn't do it and you say you didn't do it, they will say, "Okay, you need to stop lying. You need to confess. You've got this on your soul. What's going on? You're not a bad person." It is very hard for anyone in a stressful situation to not succumb to, "Okay, fine. I did it. I don't know." I do think that there needs to be serious discussion about the Reid technique.
And I know people are trying to have these discussions, but it's really hard because I think judges feel this way, and certainly legislators. They say, well, if you didn't do anything wrong, you would never confess, right? But we know so many situations of people that have. I think what's going to happen is you're going to have to chip away at it. So one area of chipping away is, a lot of states now, and I think Indiana has proposed this law not to allow you to lie to children during an interrogation. So you start there. Maybe you broaden it. Don't lie to anybody during an interrogation, the false evidence ploy, that kind of thing. And I see it a lot, especially in cases where kids have been, like this case, kids have been murdered, kids have been abused. They will play on, especially if you're like the parent, let's say your child has died, something's happened, and they immediately assume that would be, they're talking to you right after you've learned about your child's death or whatever, and they
Yeah.
use that. And they're extremely vulnerable. It's so harmful. I think we'll have to chip away at it until eventually we'll just have to have so many exonerations on the back end that maybe finally people will start talking about changing interrogation techniques. Now, what some cops do is if you say you're using the Reid technique, and we know that is coercive, they'll say, I don't use the Reid technique. I don't use it. I just have figured out my own style. It's textbook Reid, but they're like, I don't use the Reid technique.
I
I'm
made it up
just
my own
interviewing
self.
somebody. Yeah, I just interview people, right? So there's a lot of that. That's going to be the hard part. It's really a game of whack-a-mole.
So
You
so
fix
it's
this.
kind of like CRT. They change it to inclusive humanitarian studies.
And now nothing's like everybody's removing equity from their various organization names or their titles. And now it's going to go to like, diversity or access or something. I mean, they do that with the Reid technique. I'm going to call it my own personal customized way of interrogating, but it's the Reed technique.
Okay, for your final question, if you could
Yes.
change one thing right now about the judicial system, what would you change?
Oh, goodness.
I know it's kind of
Hmm.
like what color would you be and why? And
If I could change one thing about the judicial system, oh my gosh, that's a tough one. Um,
or if you want to make McClellan bald, because those three hairs that are hanging on in front with the gel, look, sir, it's a bald spot. We all see it.
Now, there was one good part in the juror interview that she recalls a story that was told to her about him having a mullet. And it's always stuck with me. And I'm not sure.
He has a mullet right now. He does slick in the.
Well, but it's slicked back, right? It doesn't look like a mullet now to me, but
He
I
looks
was
like
trying to
Miami
picture it as
Vice
a
had
mullet.
a baby with Mr. Rogers.
Yeah.
It's
It,
deeply disconcerting.
she had a lot of comments about the various attorneys, and so it was interesting to see. I mean, I'm sure it was harsh if you're one of the
Yeah.
attorneys hearing it, but me, I was just kind of chuckling about it. But oh gosh, something I would change. I mean, probably maybe that read technique would be maybe I would say the presumption is you're not allowed to, you don't talk to police unless you've been advised of all of these different things, and you have to, they can't use the technique or something. I don't know how you would ever enforce that. Either that, or it would be great if like defense attorneys had their own forensics lab we could access, that we didn't have to just rely on the state's experts all the time. Because, that's the thing. You rely on the state's experts, and you have to trust them. But if you go out and get your own, then the state says you're just a hired gun for the defense.
Yeah,
I mean,
there's no winning.
no, there's no parity there. So it would, maybe that would be something that would be nice. Or Texas has a forensics commission
Ooh,
where you can actually kind of, put some challenges through this commission, that's some kind of body that looks at different forensic techniques. That would be great here in Indiana. We need something like that to be able to start to, some of these forensic techniques aren't the best. It would be great to be able to kind of put them through a commission where they would look at them objectively, and I don't know, that those would be some ideas. But
I think mine, from having watched a lot of interrogations, if there was a 24/7, like an on-call defense attorney, because what they do when you say, "I want an attorney," is they cuff you again and take you out. Now, that is psychological right there. That is, "Okay, you don't wanna talk to us," and generally, they're telling you like, "Oh, I guess, okay, I can't help you. This was
right,
your last chance." Those are things that I don't think should be allowed.
I often wonder if when Rick went to pick up his car, if they had said, "Can we talk to you?" He had said no. Would we be here? I don't know. I
I
don't
I
know.
still have a lot of questions on how this mysterious tip was suddenly found by Grandma Murder, She Wrote, uh, and Grandma Murder, She Wrote was using pen, papers, and what, Post-it notes to keep all these tips? Why
Yeah,
weren't they digitized? Why do we not know how many tips there are? Why are we still confused?
we did pull up a clip of Doug Carter saying there were over 70,000 tips. So are they in the cabinets? I don't know I don't know where the
Also, the
tips are.
FBI said that if it was a local person, they would probably change their appearance. As I know about it, I mean, if I watched the press release, the initial one, it went on and on. Do you know someone that's drinking? Do you know
Right,
someone that's changed their hair? Do you know anyone that's been outside? Is your husband looking sad? Is your husband looking depressed? I
right,
mean, it was basically like, is anyone dealing with seasonal affect disorder? You are a suspect.
right. And it's interesting because Ron Logan, the girls were found on his property. I would have thought he would have been a prime suspect, but at the same
So,
time,
according to Kaffendinger,
yeah, I know what you're
that
talking about.
he was a main suspect for them. Now, I still
Okay,
have the problem with the physicality aspect, but I wouldn't
I
put
have
it
a different
past him.
problem though. I'm kind of like, what if you're the guy that did it? Why are you leaving the girls on your property? Isn't that like an obvious, wouldn't that
Yeah,
be
it just
incriminating? But
it it does none of this makes sense,
no,
Cara.
and there's, that's why I think if he had been the guy, why would they have overlooked? I don't know. That's the thing. There can be a lot of conspiracy theories, but it just seems like this is just the most unusual. It's just really weird. And then you can't help but ignore the fact that this tip rose again right before an election.
Yeah, where people were getting pretty pissed off that no one had been found.
Yeah, yeah.
And right after an I wanna say an EOC,
I had
filing
heard about that.
federally because according to this filing that was settled out of court, he was giving an alternate, idea about what happened in a famous child murder, which there's only one in Carroll County,
Right.
and he was demoted and denigrated and basically taken off the case.
This is the thing. Oftentimes, in cases where I feel like there's been an injustice that's occurred, it's not like one thing. It's like it's almost like everything, the planets align in such a way that all of these circumstances occur, and the next thing you know, here you are. But as soon as they had said this is the guy, and that press conference was over the top. Oh, God delivered him to us or whatever.
Oh,
um,
yeah.
I knew right then and there, tunnel vision. They're not going to come off of this. This is the guy. They don't care what you throw at them that suggests otherwise. They're going to stay. This is the guy. And that's why it was interesting because the way that they charged him as a felony murder at first, they could have alleged other people were involved, and he was just one
Well, isn't the
participant.
tip line still open? Aren't they still searching for co-conspirators?
Apparently,
Didn't Mc
except at trial, they made it clear. They said, no, no, this was one guy, and he's the only one who did it. Now, that may be because that's the story. I would love to be able to ask the juror, hey, what would you think if they had said he was one of a number of guys who did it? Would that have changed your mind any? Because that's the other thing. You go forward and you say, yeah, it was a group, but we don't know who else it was. Um,
Now, does the defense have access to the jurors to kind of interview them and see maybe what worked, what didn't, or anything like that?
if the jurors reach out to them, my understanding is they do not have their contact information, so they cannot reach out to the jurors
Oh,
themselves. And we know that the jurors were whisked away from the courthouse, so they didn't. Usually, what happens is after the trial, if it's a normal trial, the judge will say, "Hey, jurors, if you want to talk to them, you can. You don't have to." Ask them if they want to, and then the attorneys will come in. Hey, what I do wrong? What was annoying? Did I click my pen? Whatever. Things like that. They'll ask them
yeah.
questions. But other than that, they were whisked away, so they didn't get the opportunity to do that. And my understanding is they do not have the ability to contact them right now. So it would really have to be them reaching out.
Well,
Uh,
since some of them have come forward publicly, can't they get their information that way, or would it be considered harassment if they reached out?
no, they
Or does it
totally
ha
can. The only one that's come forward is the juror that did the interview, but she did not. She didn't disclose her information, no
Oh,
name or anything. They think they know which juror number she was, or at least I think most of us think we know that. But other than that, mm-mm.
well, thank you so much for walking me through what has to be the most ridiculous case ever in the
That
entire world.
continues.
It's the never-ending story. We're gonna meet
Yeah,
Falkor soon, I hope.
yeah.
But thank you guys so much, and thank you, Cara, and hopefully we'll get Delphi sorted out before 2320.
Let's hope so. Thanks, everyone.
Bye, guys. Oh, for the love of Cheetos.